Welcome back everyone. In this video I would like to talk about the RERA Act, an act which was formulated to primarily protect home buyers. So why the protection for home buyers? What was the legal landscape prior to the enactment of this act? That I'm explain further now. So before the enactment of this act, the legal landscape of the Indian real estate sector was quite chaotic really, especially when it comes to home buyers. Home buyers were literally at the mercy of very powerful and unscrupulous developers and promoters. What were some of the risks they faced? One was there was no legal rules for valuing properties, so developers and promoters would value properties to be sold to buyers howsoever they wanted, which means they would extort from buyers exorbitant prices for properties whose value was really not as much as they claimed. Or even one of the other risks they faced was frequent fund diversion. So even after extorting money from the buyers, even after they took money from the buyers as pre-deposits, their obligation was that once they took deposit from the buyers, if the home was under construction, they would use that money to complete the construction and hand it to the buyers. But they didn't do such things. Instead, the developers and promoters would simply divert that money to other projects they deemed more profitable, which means the poor buyers were literally left in the lurch, vainly waiting for homes that would take forever to be completed. So this was one of the scandals running. The other scandal running was the super area scam. So normally when you buy a flat, you are only supposed to pay for the net usable area of the flat in the building, whether it be 3 BHK or 2 BHK flat. But the developers extorted money from the buyers for even common areas such as lobbies or lift shafts, on the excuse that since you are using those areas, so you are supposed to pay for them, even though those areas are common to all the residents of the building, not just the buyer himself or herself. Nevertheless, the developers used the use of those common areas as an excuse to extort money from the buyers. The other problem the buyers faced was one-sided legal agreements. Because developers and promoters held more power in the real estate market, they still do to some extent. So prior to the RERA Act, they would take advantage of the unregulated landscape to draft agreements howsoever they wanted, in order to extort a lot of money from buyers. And if buyers could not afford to pay up, then extort heavy penalties from them as well, all without any real justification. They would essentially draft the terms of the agreement such that it was biased in favor of the developers and promoters, who could literally buy lawyers to draft agreements on such basis. The buyers, by contrast, couldn't afford to do so. So this is an example of the imbalance in power between the developers and the buyers that existed prior to the act. To some extent it still does now, but the act has heavily regulated on such imbalance and ensured that buyers are well protected now. So coming to the act now. So what are some of the features of the RERA Act? As I said earlier, the RERA Act was primarily enacted, RERA being short for Real Estate Regulatory Authority Act. This act was primarily enacted to protect home buyers from the doings of unscrupulous developers and promoters, from the abuse of power of those developers and promoters. So the RERA is essentially a central level act, but it has also devolved power at the state level. State governments, they can make changes to the RERA Act on the basis of conditions in the state and implement their own regulations. So some of the features of this act is the act has caused transparency. The act, one of the main objectives of the act is to ensure transparency. The RERA authorities at the state level, they are authorized to maintain their own websites. Even the central RERA authority has its own website, where any developer who is commencing work on a project, on a home project or anything, he is required to register said project in the website, in the RERA website, especially if the land on which said project is being built, its size exceeds 500 square meters, or if it is a building, the number of apartments in that building is more than 8. Essentially meaning that if your land size is less than 500 or number of apartments is less than 8, then registration is not required, which is a bit of a which is quite sad really, because registration should have been made mandatory for all sorts of projects. But I suppose the RERA people, the ones who enacted the act, they thought that mega projects would normally be above 500 square meters and number of apartments would be above 8, which is why they enacted this provision with that, bearing that in mind. Then the next objective of RERA is efficiency. Now, prior to RERA, if consumers had any disputes with the developers and builders, they would go to consumer courts established under the Consumer Protection Act. Now, obviously, consumer courts are also heavily burdened with all sorts of cases, not just this sorts of cases, but other sorts of cases as well, whether it be product deficiencies and so on. So because of the heavy burden of cases, consumer courts took forever to address the property dispute matters. So in order to fix this issue, the RERA Act provided for a separate judiciary in itself to administer property disputes. The RERA authority, the Real Estate Regulatory Authority, is the first level where if you have a dispute, you can file complaint before that. Then the Act has also provided for a separate appellate tribunal where you can go if you are not satisfied with the authority's decision. Then if not, tribunal's decision is also not satisfactory, then you go to the High Court and then Supreme Court, just like in normal cases. Then the other objective of the Act is to ensure accountability. So the objective of the Act is to ensure that whatever promise is made by the developer, whatever brochure they hand out to buyers and so on, that promise becomes a legally enforceable contract. That RERA ensures that developers don't get away with loose promises, that whatever they make to buyers, the Act ensures that they do the work that they are asked to do, and if not, the Act will penalize them heavily. So yes, so RERA essentially ensures that home buyers are protected from the machinations of unscrupulous developers and promoters, especially the very powerful ones. So how does RERA protect home buyers? So this Act has introduced structural changes which has shifted power back to the consumer from earlier when power was literally in the hands of the developers. So what are some of the ways by which home buyers are protected? One, whatever money developers collect from the buyers, sometimes if projects are ongoing, for each stage of construction, the developers collect money in installments. So whatever money they collect from the home buyers, the developers are required to deposit 70% of that money in a separate escrow account, and that account is to be designated strictly for that project only. Developers are not permitted to divert that money to any project or for personal purposes. That money is to be used for the project only, for the specified project only. Then the RERA also has laid down provisions saying that there should be no confusion regarding for what sort of area the builders would charge the buyers for. No more nonsense about charging for common lobby areas or lift shafts or reception areas and so on. Builders should charge only for the net usable area of the flat. where the buyers are going to stay in. So no, there should be no confusion about super built up common areas and so on. Provided, of course, if there are exclusive terraces or balconies which are exclusive to the home buyers and the buyers are willing to pay for them, then the developers could charge extra. Otherwise, the net usable area of the flat where the buyer is going to stay is the only thing for which buyers are going to charge. Then another protection is demand. When they demand money from the buyers, but they have not entered into a proper legal agreement with them yet. This was another problem in the pre-RERA scenario, pre-RERA era, where buyer developers would extort lots of money from buyers even without a proper legal agreement. So in the event of a dispute, buyers could not prove that they had paid this so money. But now RERA has introduced a restriction saying that only up to 10% of the property value, as has been properly estimated by the developer and which has been verified by the RERA authorities, not just on the developer's own arbitrary will. So with the property value, whatever money they take from the buyers prior to agreement, that should be only up to 10%. For remaining 90%, a proper legal agreement is required. Then another protection is, even after the full payment of the money, even after the construction is complete, even after the buyers move into the property and after ownership is transferred, the builders are still responsible for any defects in the property which was incurred during construction, and they are responsible for fixing this within 5 years after the possession of the property has been taken by the buyers. So these are some of the measures which the Act has taken to ensure that buyers are well protected against abuse by developers and promoters as used to occur in the past. So moving on ahead. That said, even though developers have obligations, they also have rights, and consumers have rights. The Act was enacted specifically to protect consumers, but that does not mean that they don't have duties as well. There is a proper balance in legal, even in law. One party has rights and obligations, the other party also has rights and obligations. That's how you create a proper legal contract, a balanced contract. So developer has the obligations of, obviously. The obligations are when the project is registered on the RERA website. After registering on the website, they are provided a separate login ID and password, and details regarding what is the stage of the project, and how close it is to completion, how much of it is complete. The updates regarding the status of the construction must be provided every quarter of a financial year. The developers must do so. Next is, when it comes to major design changes in the construction, they cannot decide that on their own without the consent of the buyers. Essentially, two-thirds of the allottees must consent. Two-thirds or maybe a bit less, but it's let's just say the majority of the allottees. In RERA, the buyers are called allottees who have been allotted flats in the building. The majority of the allottees, as a safety measure, as specified in the Act, two-thirds of the allottees must agree to the design changes. And of course, the design changes must be submitted to the authority as well, which must also give its consent. Only then the design changes can be made. Then consumers obviously have rights. They have a legal right to inspect all project documents, as in whatever project is under construction, or whatever, if the project is complete, whatever they are buying, any related documentation, all documentation, whether it be for the common areas or whether for their own flat, they are entitled to inspect all of those documents. And if for any reason the project is not fully complete, if the developer is not able to complete the property, or if he's just not bothering to complete it, the buyers under this act have now the full right under section 18 to demand refund of whatever monies they have paid, plus added interest if the refund is late. So these are the rights, but consumers also have duties. Like I said earlier, a balanced contract can only be if both parties have obligations and rights and they fulfill both of them. So what duties do consumer have? Their duty is obviously to make the payments on time as demanded by the developers if they can, and if the developer is in the right about having done the proper work on the project, and with 2/3 of the allottees consent, the developer must constitute a residents welfare association where the consumer must actively partake in for the welfare of the society in which he is going to stay or is staying in. So these are the duties which the consumer must fulfill along with whatever rights he has been given under the act. That way it ensures a proper balance of power between the developer and the buyer. Neither the buyer nor the developer gain an unfair edge over the other. Now moving on ahead. That said, technology has evolved and changed through the years, and it has played a huge role in the legal landscape. RERA is no exception either. Now, manual inspections earlier could have had severe shortcomings where they couldn't, where sometimes developers would often fudge up progress in the projects to make it as though they progressed a lot more than they have, or sometimes bribe inspectors to write false progress reports to entice poor buyers into paying up more money than they should. So the technology has helped to fix a lot of issues. There are three ways in which technology has enhanced how RERA governs real estate. One is geotagging and AI. Geotagging as in using satellite imagery and drones and so other ways to monitor project construction, and essentially using real-time video footage and images to keep track of the progress. State governments and the central government can now use satellites to monitor the progress of specified projects and use real-time video footage and images to keep a track of the project's progress, and that way the data which is specified in the RERA website regarding the projects would also be updated real time, and the quarterly progress reports that the developers would file would also match with the real-time footage obtained from the satellites. So again, geotagging and AI have helped a lot in ensuring that developers are kept in line, that they fulfill their obligations properly to the consumers. Then another way is blockchain titles. So blockchain titles as in what exactly is blockchain titles? So there is a separate websites where land records are properly maintained, so that way documents are not properly fudged, and that clear titles to the property are properly established, that there is no dispute in ownership. This is especially the case when developers happen to transfer property to another third party, which incidentally under the RERA Act they can only do so with the full consent of 2/3 of the allottees and the authority. But under blockchain titles, this is a technology that's being used to ensure that proper documentation, real-time updates and documentation is maintained regarding the ownership of land and building, and transfers of the such land and building as take place from time to time. That way the transfer of ownership and the records of ownership are properly maintained. Then there is this single window portal. Now as I've said earlier, RERA, the Act has authorized the maintenance of its own website where developers can maintain the details of whatever projects they are working on. They are supposed to provide the details of what projects they are working on and provide quarterly updates. And the portals on this website, they usually link municipal permits, so which means in this website it can be found out whether the project had proper clearance, whether it was deemed environmentally safe, whether it was also deemed, whether the materials used in the construction were deemed safe enough for staying in, that the building wouldn't just collapse on itself overnight, thus endangering the lives of the people staying in and so on. So all of these documents are also supposed to be properly maintained and updated in the RERA website, in the RERA account of the developers who have been registered with the RERA website and so on. So that's how the technology has evolved to help the RERA authorities and the Act itself properly govern the real estate landscape in India. So what has been so in the 10 years since RERA was enacted in 2016, so this act has had a very beneficial impact apparently. The real estate market, which was very chaotic and highly biased in developers' favor, has heavily matured, where developers and buyers now share equal power, and there is more accountability for home buyers. Developers are now more and more accountable to home buyers for proper performance and for giving the proper value for money to the buyers. So state governments up to now have successfully disposed of 160,000 property disputes that were filed before the RERA authorities. Then when it comes to recovering money from developers who have not completed the projects on time, there has been a 90% recovery rate. Then when it comes to delays, if the buyers can choose to withdraw from the project if there is delays, but if they choose to stay on, then they are entitled to be paid interest for every time for each period of delay. So the interest rate is 10.5%. Then yes, so just to say conclude, just to sum it up, we can see that RERA has had a very good impact on the home market, on the real estate market in India. This act has helped to expand the real estate market further by introducing proper regulation, thus making home buyers feel safer and safer in buying homes for themselves and so on. So there was a case law which pertains to refund under section 18. This case is called New Tech Promoters. It was brought before the Supreme Court. So apparently the New Tech Promoters had constructed a building, but because the building was nearing completion, but it hadn't been completed on time, so buyers were dissatisfied with the way the project was going, so they demanded refund from the developers for the delay in completion and and withdrawing their involvement from the project. So when the case was taken to the Supreme Court, the developers argued that the project was literally 95% complete or 99% complete, whatever. So that the buyers had no right to cancel their purchase in the project, and they had no right to the refund. However, in the judgment that was passed, the Supreme Court held that buyers had an unqualified, unconditional right to refund should they demand it and should they have the proper legal proper grounds to do so, regardless of what the developers argue. They have the right to withdraw from the project as soon as it is agreed that the project is going nowhere or the project is taking too long to complete. So it was decided that the developers would after all refund the amount to the buyers along with interest as is stipulated by the Act for regarding the period of delay. How much was the period of delay? So this was an important case that buttressed the refund provisions under Section 18, thus providing a layer of protection to the home buyers in the event of delay in completion of projects. Then moving ahead, there are two more case laws which protected home buyers, but at the same time one of the case laws has ensured that only genuine home buyers should be protected. So there was this case law called Amrapali Group ruling, where Amrapali the Amrapali group of companies was involved in constructing projects, but because it was believed that they were negligent in the construction or that there were continual delays in the construction, so the case was taken to the Supreme Court. The Supreme Court cancelled the group's registration under RERA and mandated the NBCC, a governmental body governing the construction industry in India, to complete the construction. So again, this is an important judgment which emphasized the protection of home buyers from the abuse of developers or from the negligence of said developers. And not only that, apparently Amrapali group of companies had declared itself insolvent. So they had apparently the case had gone to the Supreme Court because the home buyers were aggrieved at the way the supposedly insolvent company was bailing out on its dues to the home buyers, literally stealing their money and so on, or rather not providing proper homes. So the Supreme Court cancelled the group's registration because they were insolvent and authorized the government body to complete the construction, thereby protecting the home buyers from corporate abuse and insolvency, and emphasizing their rights to live in safe and proper homes. Then another case was Mansi Bra Fernandez. Now what had happened in this case was there had been a group of people who had purchased homes in a building, but these people were not intending to stay in those flats. They were more like buying the homes for sale later. Essentially, they were like speculative buyers, something akin to how people buy shares on stock market and sell them immediately as soon as there is a high enough price. So the buyers had taken the case to the Supreme Court, hoping to get the projects completed and get the homes sold quickly at a high price, in the hopes of securing a high price once the project was completed. However, the Supreme Court rejected their claim, saying that the act was only for protecting genuine home buyers, people who genuinely intended to stay in the apartment once they chose to buy it, and not simply sell it off as soon as possible for a high price. Not merely speculative investors, more like genuine residential home buyers. Essentially, these buyers had dragged builders into insolvency. By hoping to drag them into insolvency, they could claim money from their builders for their own profit. Thus, Supreme Court put a stop to that nonsense and introduced the speculative investor trust. This was to ensure that bulk buyers, speculative buyers really, or investors, they would not be allowed to unnecessarily drag builders into insolvency just so they could extort more money from the builders. That way, projects would also be shielded from the scourge of speculative investors, and they would genuinely be for actual home buyers. So essentially this judgment ensured that the act would only protect actual home buyers, not speculative investors. So these two case laws, they essentially safeguard genuine home residential buyers, that judgments ensure that one single investor does not have power over the entire project, that they cannot stall it just because they want to do so. And these judgments are ensured that the interests of families who are desperate families who are awaiting to stay in safe and sound homes, they get to do so. So these judgments have buttressed the act and ensured safety for home buyers. Of course, it is not fully complete. the law still remains to be refined even further to ensure better protection, which will be done later on, but that's a matter for another time. The law is changing time to time on the basis of conditions. So there will be more judgments to look forward to. That we'll have to see later. So moving on ahead. So that said, RERA has its own forums. Under the RERA Act, it has established its own judiciary, sort of quasi-judiciary you could say, for settling disputes under the Act. The RERA, the Real Estate Regulatory Authority, and the Real Estate Appellate Tribunal, both of these are authorities established under the Act. They both have the powers of a civil court to settle disputes the way any court would. That said, there are options you could still choose from. You can still choose to settle outside of RERA. Like one of the primary modes of settlement of dispute is consumer forum, consumer courts, which used to be the case before RERA. So the primary goal obviously in consumer forum is compensation. The consumer forum will not ensure that you get to stay in the property, but it would ensure that you get the refund. That said, because consumer forums are heavily burdened with cases, so the stay in the consumer forums, as in the disputes in the consumer forums, would go on for a long time, like 2 to 4 years. And because of the heavy amount of money involved, that would mean that there would be, essentially that would mean that buyers would have to wait for a long time to recover huge amounts of money, and buyers could potentially be rendered bankrupt. Their money would be locked for a long time in projects that they could spend elsewhere. So there's essentially a sort of civil code which would ensure that compensation is awarded. Now this is, if you want a headache, if you want a long case, and if you want to ensure a long time for compensation, you can go to consumer court, but it's advisable not to, because it's huge amounts of money, and it's best not to go to consumer courts. It's advisable not to go to consumer forums at all. Then another forum you could go to is NCLT, National Company Law Tribunal. Now primary goal here is debt recovery. If you are, for instance, a debtor of the property builder in question, and they are defaulting on their dues, so you want to recover your money, you can file a case before NCLT. Case before NCLT would go on for 1 to 2 years. However, here recovery would be pro rata. Your claim might not necessarily be priority, because the NCLT would decide the settlement of claims on the basis of which party has the first right, has the prior right. So if you are not in the prior right, then you would not get the money that you want. So this is usually for if the builder is bankrupt and you want to recover money, then you can file a case before NCLT. Then obviously the third forum which I talked about right now is under RERA. As I said earlier, RERA has its own authorities under the Act. Real Estate Regulatory Authority is the first, Appellate Tribunal is the second, High Court third, Supreme Court fourth. So if you are going to file a case before RERA, your goal should be to ensure possession of the property that you had bought, or if you do not want the property or you want a refund, to ensure refund as well. The speed of the case that would be solved before RERA is much lower than either of the two forums. It's just 6 to 12 months, maximum 12 months, minimum 6. So recovery, so how would money be recovered here? It would be recovered on the basis of the land revenue. Essentially, you would get the full amount of the money you paid for in RERA plus interest if there was any delay. So this forum is definitely the one to which RERA has established and which is recommended to go to under this act in case of a property dispute. This is best for if you want to secure a home for yourself or you want a refund on money due to delay. So RERA authority is best. So my personal advice would be, since the act itself has established these authorities for property disputes, best go to the RERA authority for your dispute. Don't bother with the other two. If the builder is not bankrupt, no point bothering with NCLT. Don't bother with consumer forum either unless you really want to face a long litigation and unnecessary legal expenditure. So it's best to choose the RERA authority for property dispute resolution. So fast track justice. Now how do you file your RERA complaint? So one way to file your RERA complaint is you could visit, first step is if you have a complaint against any builder or developer in whose property you bought a unit or something, then you could visit your state's RERA website. Like if it is in Maharashtra, it is MaRERA, or if it is Uttar Pradesh, UP RERA, then you could create a citizen account, your own account on RERA. Then next step would be you should upload the necessary documents relating to whatever property you bought. Namely, you could upload your agreement for sale, whatever agreement you had written and signed with the buyer, with the developer. Then whatever payments you made, installments depending on the stages of construction, those payment receipts, and when the property was allotted to you by the developer, the letter of allotment with dates of allotment and so on. Essentially, the agreement of sale, payment receipts and allotment letter, all of these should have the dates on them. That way the time period would become much clearer, since in disputes the time period from which certain things happened are very important. So dates on these agreement documents are very important. So if these documents have dates, ensure these documents have dates. Once you have these documents, upload them in your citizen account. Then filing of complaint, if it is the authority itself, fill out form M, or if it is an adjudicating officer, like one adjudicating officer, it depends. If it is a huge property and the value is like in crores or something, then authority is better. Authority is recommended. If it is property is not really much, like say a couple of lakhs or something, then adjudicating officer. So fill out these forms for compensation. Form M for authority, Form N for an individual adjudicating officer if you want compensation. Then once the forms are filled out, the authority or adjudicating officer would provide a date of hearing. On the date of hearing, attend the hearing on the website itself. No need to go all the way to the authority. Via video conferencing on your computer itself, you can attend the hearing, and you can either represent yourself or you can hire a lawyer or advocate to fight for you, just like in a normal court. Then once a hearing is done, once the matter is decided, file for execution. You can apply for a recovery certificate in order to recover what a recovery certificate. That way you can submit it to the collector, and that way whatever monies you paid to the builder or developer, that would be recovered by the collector using the recovery certificate. That should in then be transferred to you. So this is the steps if you want to file your RERA complaint and settle it on time before the first authority. Before the second authority, appellate tribunal, if you are not satisfied with the authority, you can go to the tribunal. There you would be required to deposit there. Also the case would be heard, and if it is not satisfactory to you, you can go to High Court and then Supreme Court, just like a normal stages of court appeal. So moving on ahead. So concluding this video, RERA Act was primarily enacted for your safety as a home buyer in order to ensure your rights are secured. So before you choose to buy a property, buy a flat in a property, or before you choose to sign your next check for the property, visit the RERA portal, visit the builder's account, visit the details of the property that the builder has registered, find out how much of it is completed, find out if the property is properly registered, monitor, read the quarterly progress reports that the builder puts in continuously, and check if how close the property is to completion, whether there is any progress in the property construction. Then when it comes to sales agreements, hire a legal lawyer of your own, or if you are well versed in the law yourself, do your best to ensure that the agreements are in accordance with the terms of the law of contract and with RERA. Just hire a legal counsel really to do all this. Then keep an eye on the real estate market. Find out how building construction is going on in the area in which you are purchasing a flat in a property. How close the other buildings, the other properties that the builder has, what is his history of constructing them, how long it took to build them, and what other projects he's working on, how close they are to completion, how close other builders are to completion of their projects. Check it out, all of this. Check out all of this. Essentially, to sum it up, just visit and monitor the RERA portal of the builder's property regularly if you are planning to buy a flat in it, and make sure your rights are well protected. Hire a good lawyer in order to secure your rights. So use RERA properly when you are buying a flat. Use the protection provided by RERA properly when you are buying a flat. So I hope this video, those of you who are potential home buyers or who are seeking to buy homes, I hope this video helps you all while you are purchasing homes. I hope this video helps you all understand the legal protections you have while buying a home. So thank you all for watching this video. I hope this video has proved very helpful to you all. Please like, comment and recommend my video to anyone else you know, particularly those who are buying homes or going to buy homes. Then please also subscribe to my channel at Siddharth Bhatt 4898 and recommend my channel to anyone else you know. Once again, thank you all for taking the time to watch this video. Thank you all for taking your precious time to watch this. Thank you all once again. Thank you. Thank you.